Hello, everyone. I'm Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists, and as uncertified podcast co-hosts, we try to bring our audience of trial and appellate attorneys some news and insights they can use in their practice. If you find this podcast helpful, please recommend it to a colleague.
Yeah, if it's not helpful, recommend it to your opposing counsel. And a quick thank you to our podcast sponsor, CaseText. CaseText is a legal research tool that harnesses AI and a lightning-fast interface to help lawyers find case authority fast. I've been a subscriber since 2019. I highly endorse their service, and listeners of our podcast will receive a 25% lifetime discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
All right, Jeff, and today we're going to continue our tour through the country and talking with other appellate practitioners in other states so we can compare are all these soapbox issues that we talk about grousing about California procedure. Maybe California is the same or better or worse than other states. So today we're pleased to invite appellate attorney Lindsey Lawton to the show. Lindsey is an appellate attorney in Florida, and until late 2020, she was a career staff attorney to Justice Alan Lawson of the Florida Supreme Court. Before that, Lindsey was a career staff attorney to Justice Stephanie Ray and a senior law clerk to Judge Joseph Lewis Jr. of Florida's First District Court of Appeal. Lindsey spent nearly 4 years at the Florida Supreme Court and nearly 10 years at the District Court. During that time, she evaluated hundreds of appeals and extraordinary writ petitions, including researching, writing, and making recommendations to her judges and justices. In late 2021, Lindsey presented for the Florida Bar's Appellate Practice section on appellate brief writing, which will be apropos as we discuss legal writing during today's podcast. Welcome to the show, Lindsey. Thanks for being here.
Thank you, Tim and Jeff, for having me.
Well, let's start off by asking you to tell us a little bit more about your practice. Is there anything I didn't cover in my introduction that we should know?
Yes, I am. Well, I always get confused about how to explain what I am. On the one hand, I am a solo practitioner because I have my own law practice called Lawton Law, where it's just me. But I actually also work closely with another law firm too on many of my cases in an of counsel role. And that law firm is the Brownlee Law Firm out of Orlando. And pretty much everything I do is appeals and a little bit of trial support.
All right. Well, what do you like best about your practice? You moved from working in the Court of Appeal system to being a private practitioner. Jeff and I moved from working in litigation to moving up into appellate work, and I think that sometimes we had to remove some of the harder adversarial edges from our practice, and maybe you had to get more adversarial in the way you write and advocate.
We had to remove a lot of adverbs from our vocabulary when you move from the trial court up to the Court of Appeal.
Always a good idea.
Yeah, tell us about that transition from a career research attorney in the Court of Appeal to private practitioner.
Sure. So when I left the court system, I was aware of the concern that a lot of people have about whether they can transition from being in this neutral role as a law clerk helping the judges to an advocate. So I talked to a few of my friends who had gone before me making that transition to get some pointers. One of them recommended that I read Brian Garner's book, The Winning Brief. So that was the first thing I read to help myself with the transition, and I think it helped out quite a bit. It didn't really feel like that hard of a transition. And I think for one reason is I think the better briefs do sound more like the court's writing than what some people might think. They don't have all those adverbs and like just sort of bombastic language. Of course, you do want to punch it up just maybe one notch. And so my colleague Mike Brownlee has helped me punch mine up just a little bit. So it's always good to have another set of eyes on your writing, but for the most part, I think the courts like it when you write in this more objective sounding way. So I think my background has served me well there.
Yeah. Well, let me ask you this. As you were talking, I got to thinking that sometimes when I write for the Court of Appeal, I will versus when I write for the trial court. When I write for the trial court, I feel like I have to. You said to kick it up one notch from judicial writing. When I'm writing in the trial court, I feel like I have to kick it up 2 notches because sometimes opposing counsel has got it up, to turn to 11, and sometimes I think, oh well, they're just going to lose the judge, but sometimes the judges go for it. They're like ruling based on, well, this party had more adverbs. They obviously feel much more strongly about their argument than you do, Mr. Kowal. So they must be right. Is there any merit to that? Do trial judges, do you think, maybe because they're pressed for time, they just have more on their calendar that they will just look to who has the loudest brief and maybe put a thumb on the scale in that way, even imperceptibly, without them knowing they're doing that? I wonder if they do that sometimes.
I don't know. I don't think there's any way to know. And I don't usually appear in the trial courts, but even in the appellate courts, sometimes my opposing counsel will have it taken up a couple of notches.
Yeah.
On the adverb front or the just being loud front. And I just hope that what I've heard from judges is true, that they don't really respond well to that.
Yeah. Well, given your long background in the Florida state appellate system, I think this almost goes without saying, but I'll ask anyway. Would you rather be in state court or in the federal court, the 11th Circuit in Florida?
Well, you predicted it. I would rather be in state court, I think. My background is in state court, but with that said, I have had a few federal appeals already, and I'm learning the ropes over there and doing whatever I've got to do to learn what I need for each case. So
yeah,
it's just less familiar, but there are a lot of overlap and a lot of similarities too.
We're going to be talking about differences between California and Florida state rules of civil procedure and appellate procedure a little bit later on. Are there any differences that you discover between state law and an 11th Circuit procedure that can tend to trip up practitioners?
I don't. None are coming to me. I'm sure, and I know there are differences.
Sure.
Yeah.
What about would you rather be the appellant or the respondent, or is it the appellee in the Florida system?
In Florida, it is the appellee. When you're talking about the appellant versus the appellee, of course, we also have petitioners versus respondents. Right. But I would definitely. I'm pausing because I said definitely. I would say I'd rather be
internal editor.
Yes, I definitely would rather be the appellee or the respondent in one sense. And that is statistically the appellee and the respondent are the most likely to win. And we all like to win. But being the appellant is more of a challenge. And you're really creating the product from the ground up a lot more. And so it can be more interesting.
We sometimes ask our guests to tell us what is unique about their legal practice, but with you, Lindsey, I think I know the answer because after reading your bio and talking with you offline, I know you to be a dedicated amateur of language, and I give amateur the classical meaning, a person who lovingly pursues a study not as just a mere means of trade, but as a devout disciple. And in your bio, you say this about your relationship with language. This is Lindsey Lawton. I enjoy language, all language, written, spoken, sung, and signed. I mean everything about language, from delightful nuances in the meanings of words to the beauty of different dialects and the connection between linguistics and culture. I'm sometimes mistaken for the grammar police, open parenthesis, only because I make a hobby of handing out helpful tips, close parenthesis. And it goes on a bit. Tell us more about why you're so enamored of language and how that makes your practice unique.
I can't give you, I don't know why I'm so enamored of language, except that I would just compare it to, the reason that I like ice cream and chocolate. It's just, it tastes good.
It tastes good.
I enjoy language. It's just natural to me. And I always enjoyed reading as a kid. I had great English teachers in high school and went on to become an English major, probably because of that. I also was a Spanish major. So that's part of the, it's not just that I love the English language or the grammar. I love linguistics and language. And so it's just natural to me. And how that makes me and my practice unique, I guess I'm just the grammar rules have always stuck in my brain. And so for the most part, my writing is going to be very polished from a grammatical perspective, and I'm going to enjoy the process of it, which I believe translates into a good product and a good something enjoyable to read.
Yeah, in California, it's about 70 to 90% of all appeals go nowhere, depending on whether it's a de novo review from a motion or substantial evidence review from a trial. You guys have similar stats in Florida in terms of the prospects of an appeal?
Yes, it's very similar. I know there's one appellate court that I've been to a lot of CLEs at where the court provides its statistics, and I think it's somewhere around like 85% of the cases get affirmed.
Wow.
Oh, that's even higher than in California. Yeah.
Yeah, I mean, and that's just that figures is pulled out of 1 year, so it can vary, but I think it's pretty close. I don't think it would. I haven't seen the number go down as low as 70.
Lindsey, you and Tim are super active on LinkedIn. I get on there once a week to read, and you two are really active. How do you find the time to write and to spend time doing not just a post of your cat, but really substantive, helpful advice on LinkedIn?
Well, I have kind of a topic that I post about, and it's a topic that I'm very familiar with. And as you both know, it's typically I post little grammar tips. And so the one way that I find the time is that I'm writing about something that I already know and don't typically have to go and do any research to write. And I keep them my posts I keep very short. I kind of keep in mind that LinkedIn, even though it's professional, it's social media. So I kind of have my social media persona on there where I'm just sort of speaking off the cuff about a topic I know pretty briefly. It still can take a lot of time though, because especially when you get into discussions with people underneath your posts or underneath their posts. So you do have to be careful not to let it suck you in and use all your time as social media tends to do.
She's looking at you, Tim, in terms of all your comments. She's looking right at you.
Right. No, I appreciate all the comments. Keep them coming. But I go through phases where I'm posting more or posting less, depending on what's going on.
Interesting.
Does it ever
but I usually don't like sit back and spend a bunch of time writing the original post.
That's right. Yeah. When you write something that you know about, and especially something that you love, then it makes it easier and more fun and enjoyable to do. Do you ever feel self-conscious, Lindsey, writing grammar tips? Do you find yourself when you're writing the grammar tips, oh my God, I hope I don't have a subject-verb disagreement in this post somewhere, and all the my audience of grammar nerds are going to pounce on me?
Definitely. It's not uncommon that there is a mistake that I find after I hit post. Sometimes people point it out to me, and sometimes I catch it before anyone points it out. But it's a little tricky because the algorithm experts on LinkedIn say you're not supposed to edit for a certain amount of time if you want your post to have any reach. So
I didn't know about that one.
Yeah. Sometimes I sit there and let the mistake be there, but
yeah.
Well, hopefully people understand that it's just a mistake and not reflective of my knowledge of grammar.
Yeah. Now, can you share with us maybe one or two of your grammar tips, maybe the ones that you've shared on LinkedIn or ones that you've not shared, maybe some that you feel are the top grammar tips, or the top faux pas that attorneys make regularly, something that you could share with our audience today.
Yes, okay, I have two favorites, I guess. The first is I'm giving you some permission. The second is I'm telling you something not to do. So the permission is you have permission to use the word that. A lot of people want to strike the word that in writing as much as possible. I don't really know where this advice to strike the word that originated from. I can tell you that in all of my education, like in writing as an English major, no professor ever told me to strike the word that. And it was after I became a lawyer, a fellow law student was editing my work one day, and she wanted to take out the word that, and I had never heard that before. Since then, I have seen that it's kind of this common editing approach. But a lot of times, the word that is important to a clear meaning of your sentence. And so I would say err on the side of keeping the word that in. Don't take it out unless you have some good reason, other than that someone told you the word that is excessive. If it sounds natural, keep it in. The second one is lawyers tend to misuse the phrase as such. So a lot of times people will use as such to be a synonym for therefore or thus, but it's really not. As such is a phrase with a pronoun in it. The pronoun is the word such, and such has to refer back to a noun that you already said in the sentence. It is not just a synonym for thus and therefore. So be careful with that one.
Interesting. I hadn't thought about it. I don't like that phrase, so I stopped using it a while back. But you made me think of another phrase that we use almost unthinkingly that is a verb, and so as such it has to agree in whether it's singular or plural with the noun that it's referring to. So when you end something, the reasons are as follows. Reasons is plural, follows is a singular, so you should say the reasons are as follow. Although that sounds really weird to me, and that violates my first rule of grammar, which is if it sounds stupid, it's not English. So I'm left with just leaving all these disagreeing subject-verb clauses in there, using as follows when it refers to a plural noun.
It's funny you bring that up because I had the same thought as you on that. At some point, I started changing as follows to as follow. And then someone told me I was wrong, and I don't know who's right, but I switched back. I always just say as follows, and I just take the as follows as referring to this big chunk of language and not as to the individual reasons.
Yeah, you can almost hyphenate as follows. It's become a term of art.
Yeah.
List starts now. Is basically what it means now. Okay, well, let's get to business and talk about some comparisons between Florida rules of civil procedure and California rules of civil procedure. We've talked with guests from Illinois and Utah, and Lindsey, you're really the one that kind of kicked this off in my mind as this being an interesting comparison to make. And it was when you told me that in Florida, the appellant doesn't have a right to a reasoned opinion on an affirmance, and I thought, well, by God, that's awful. You poor Floridian appellants who don't get a reasoned opinion, just a summary affirmed. And I thought, gosh, I'll have to take a break from my soapbox and give the rules of appellate procedure writers in California a little bit of an easier time, because at least we get a reasoned opinion in all of our affirmances. So I wanted to ask you some other questions and see where things come down in California versus Florida. One issue that I like to explore is the question of who sets the rules of civil procedure, the court rules in Florida. Is it the legislature, or is it the Supreme Court, or is it some mix of both?
It is the Supreme Court. How is it in California?
We have a statute. Code of Civil Procedures is set by the legislature. We also have the rules of court, which are set by the Judicial Council, which is under the Supreme Court, but they may not conflict with the Code of Civil Procedure. If there's any if there's any statute on point, the rules of court may only elaborate but not contradict.
So it's the state legislature that tells us we have to do a meet and confer before we file a demur, or all those other procedural rules, and not the courts. It's the it's the state.
Wow. Yeah, I was really surprised to see that.
Well, and that's how it works in Utah as well. We talked with John Nielsen about that, and then that turned into another question. The biggest practical difference that I know about, or that may be a result of the legislature versus the Supreme Court deciding the rules of civil procedure, may be answered when I ask you this next question. Are court reporters required? Is a reporter's transcript required for an appeal? Does it have to be? Let me ask it a better way. Do you have to have a court reporter at the proceeding taking down a simultaneous transcript, or can in Florida can you have electronic recordings of a proceeding that can be transcribed later to be used as the appellate record?
You can have electronic recordings. I say that because I think in certain proceedings, like some criminal proceedings and maybe a few others, I don't want to name them out in case I'm wrong, there is a digital recording that can be transcribed. But in just regular civil cases, the court doesn't provide a reporter or a digital recording. You have to arrange for your court reporter.
In Florida, is there a crisis of a shortage of court reporters? Do you have that problem like we have in California and in many other states?
I have not yet encountered it, but I've been hearing that it is affecting Florida too. So,
in what ways is it affecting Florida? Because if I understood right, you don't normally have to have a court reporter present in order to make an appellate record because it's still digitally recorded.
Oh, well, in most cases, it's not digitally recorded. So in civil cases, you definitely have to arrange for your court reporter to come to the hearing or the trial, to be clear. And I'm just saying that there are a few types of cases where there are digital recordings made, but I would never rely on that without checking with the court to make sure that's going to be the case, because it's very important to an appeal to have a transcript, whether it's something transcribed from the digital recording or from a live court reporter who was sitting there. And as far as like, I've been hearing just probably on LinkedIn and from others that there's generally a court reporter shortage in the country. I haven't talked to any attorneys who told me that they couldn't find a court reporter for their proceedings. But I did Google it to see if it's affecting Florida, and I just saw an article online saying that it is, but I have no personal experience to know for sure.
Yeah. The background in California is that there's a statute that provides for court reporters. It doesn't forbid, at least doesn't expressly forbid, the use of electronic recording, and so the legislature created a pilot program back in the 90s, but when it sunsetted, by that time the court reporters union had gotten wind of it and shut it down. The Judicial Council decided, well, the electronic recording is a good idea. It's important for access to justice that everyone have access to a court reporter or to an appellate transcript, and so they provided for the use of electronic recordings. And then one of our district court of appeals decided that conflicts with the statute, so that Judicial Council rule of court has to be struck down. And so that's where we have been for the last 25 years, or close to 30 years, I think, where a verbatim court reporter transcript is the only game in town, effectively, for making an appellate record. And there have been numerous efforts by the legislature to create another route for using an electronic record, but they've all fallen upon the same fate. Let me ask you about horizontal stare decisis. We've talked about that on the podcast. One of our district court of appeals can just thumb its nose at another district court of appeal. It does not have to follow the holdings, even though they're directly on point. What say you in Florida? Do you have horizontal stare decisis, where all the district court of appeals are considered, to be one court, and they have to follow each other to be consistent?
We do not. We have we have 6 district courts of appeal. That was recently a change in Florida. We used to have 5. Now, as of January 1st of this year, we have 6, and they are all independent and can disagree with one another.
What about so Florida is similar to California in that regard. What about in California? The first district court of appeal could thumb its nose at its own opinion from yesterday morning and decide to go the complete opposite way on the same point of law. What about in Florida? Does the same district court of appeal have to follow its own prior holdings?
So the district courts of appeal sit in 3-judge panels to make their decisions, and so a panel does have to follow the precedent of its own district, but the court can go en banc and reverse its precedent.
Okay, so that's very much like the federal method of taking these things, taking the prior decisions en banc and reverse it, if it wants to revert itself. But a 3-judge panel cannot do it on its own.
Correct.
Okay. Interesting. So that makes Florida's state appellate system very similar to the 11th Circuit and the other. I assume all the federal circuits work a similar way. I only know the 9th Circuit to be sure, but I assume the 11th Circuit and the other circuits work similarly. Now I wanted to ask you about the other soapbox that I like to get on most often, about unpublished opinions. In California, the minority of our district court of appeal opinions are published. The vast majority are in the subterranean body of law of unpublished opinions. Now they're all there, accessible on Westlaw or Lexis or on our podcast sponsor Case Text, the best of them all. They're all there. You can find them just as easily. They appear in searches just as often as published decisions do, but they're unpublished. You cannot cite them for any reason. I was about to say cite to them, but I know Lindsey says you should not say cite to. You cite a case. You cannot cite an unpublished opinion for any reason, technically not even to the Supreme Court, to show that there is a split of decisions, even though that rule is flouted with regularity. How does it work in the Florida state system? Are there unpublished opinions?
There are not typically unpublished opinions of the Florida appellate courts. Every opinion deciding a case in Florida gets published. The orders that they may issue along the way aren't necessarily published. Occasionally, the court will issue an unpublished order that might have some substance. There's no prohibition on citing it, but I mean, as you say, it's not precedent if it's unpublished. If you do cite it, you're not going to get in trouble. It sounds like you might get in trouble in California if you cite an unpublished opinion.
Yeah, you can get in trouble there. Have we seen any cases of litigants getting sanctioned, Jeff?
Not for that alone, but usually the same kind of litigant who cites an unpublished decision might, I don't know, not have an appellate record, not make points in a heading, commit all sorts of other fatal appellate sins.
Right. If you were to cite only unpublished opinions for an authority, then I think it would be a very good chance that the court would deem that argument to have been forfeited.
Yeah.
What if there's no appellate decision on point?
Then congratulations, you're about to make new law.
but you can't cite unpublished works.
No, right. You still can't. That's a good reason to look out for any unpublished opinions that raise issues or decide issues of law that haven't been taken up before. And any person, doesn't have to be one of the parties, any person can make a request for publication in the Court of Appeal. So I've done that personally a couple of times in the last year. I think 2 out of 3 of my requests have been granted. So it's it can be frustrating to see issues that have never come up before, and then they're disposed of in an unpublished decision.
Right.
Well, let's talk about written opinions now, Lindsey. We have in California a right to a written opinion on appeal, and I know Florida does not give litigants a right to a reasoned opinion when it affirms. Can you tell us about that? How frustrating is that? How difficult are the conversations with your client when you go back and say, I'm sorry, we put up our best fight, this really great argument that I thought would win over the court didn't buy it because, and then you can't finish that sentence because you don't
right.
know how the court felt about your slam dunk argument.
Yeah, well, it is frustrating as an advocate, and it is certainly disheartening as an advocate and for the client when there's what we call it a PCA. It stands for per curiam affirmed, which a PCA is a decision with no explanation, affirming. And so, you hit the nail on the head. It can be frustrating for both the attorneys and the clients. Personally, I know that when a PCA is issued, that a lot of work went on behind the scenes to reach that result, but it still can be very unsatisfying for the clients. And it is, even as an advocate, often I'm wondering, I want the explanation.
What about
was there a second part of your question?
Yeah. Well, what about in cases where, there are cases that I've argued and that I've seen opinions on where there are technical defects in the appellant's argument. Say that there's a defect in the whether it's not an appealable order, or it was an untimely appeal, or an issue was waived or forfeited by the attorney, and yet the arguments are still good. And even if they're not so great, sometimes the panel just decides, you know what, I don't want to set up a malpractice trap for this poor attorney. So we're going to go on, excuse me, and say that despite this issue, even on the merits, we would have affirmed, and then explain why they rejected the appellant's arguments on the merits. And I take it you don't get that happening as often in Florida. You might be left with the client asking the attorney, well, do you think this is because you screwed up at the trial and you didn't preserve the issue correctly? And then does that create, does that create a malpractice problem? Wouldn't it be nicer for that reason to have more reasoned opinions on affirmances?
That's a good point. I think a lot of appeals probably come down to lack of preservation. But yeah, I mean, and I've seen written opinions that go into, well, this was not preserved, but like you say, we would affirm anyway. I don't know that the clients are looking at it from that perspective, blaming the attorneys. But yeah, that is one reason that it would be nice, so that there could be some certainty there. But I guess that's something that would be fleshed out later in a malpractice suit if unfortunately that happened.
Yeah. And Jeff, did I remember correctly that John Nielsen from Utah told us that they often do not have reasoned opinions on affirmances, and that many of their...
I think that's right. I think he did say that.
Okay. The next question I wanted to ask you about has to do with, let me see what it had to do with. Let's talk about some briefing follies. Jeff and I were just talking a moment ago about how in California there are a lot of ways that you can lose arguments. For example, if you don't put a key argument under its own heading in the brief, the Court of Appeal could decide that no, you buried this argument, so we didn't have to reach it. Or if it's not accompanied by citations to authority. Now you got me self-conscious, Lindsey, because before taping you said you should say citing, not cite the case, not cite to the case. Anyway, if you don't cite to authority or to the record, you will have deemed to have forfeited those issues. Do you have similar kinds of trap doors in briefing in Florida?
Yeah, I mean, I don't know that I would call them trap doors, but we do have an appellate rule that says, let's see, it lists out the contents of your brief, and one of them is, I'm looking at it says a table of contents listing the sections of the brief, including headings and subheadings that identify the issues presented for review. I've seen cases, an opinion, and I should have grabbed the site before the podcast, but I didn't. But I've seen opinions that talk about, oh, I'm sorry, the part of the rule I'm really thinking about is later. The rule talks about organizing your issues clearly and cogently. And more than that, I've seen appellate opinions that would say an issue was sort of just alluded to or just hit very perfunctorily, and that's not sufficient to raise an issue for appellate review. And I guess I would say I wouldn't consider it a trapdoor, because I think someone writing a brief should know that you have to flesh an issue out and make an effort to persuade the court rather than just, name the issue and tell the court to figure it out.
Yeah.
Yeah.
No, I've seen that before where as the appellate attorney, I decide, look, I want to argue issues A and B. These are the issues that you're likely to win on. But then the trial attorney still says, yeah, but you got, W, X, Y, and Z were really great issues. And I don't think they're so great, but the trial attorney insists they go in there. And so I might just throw them in at the end in a kitchen sink argument. And I've done that. I did that years ago in the Court of Appeal. I won on issues A and B. And then the court went ahead and said, issues W, X, Y, Z were not fleshed out enough, didn't have separate headers. So we're deeming them waived. They could have been useful to me, but I think they would have lost anyway.
Lesson learned.
I have seen that happen.
Yeah.
Let's talk a little bit about summary judgment procedure. We've talked about on the podcast that if you're opposing a motion for summary judgment on the grounds that you need more discovery, in California, you must file a motion under our Code of Civil Procedure, Section 437C, subsection H. You have to file this motion, explains why you'd be able to show a tribal issue of fact if only you had this discovery, and explain why you haven't done the discovery until now. Is there something similar to that, or are there other tricks or traps to be aware of in Florida motion for summary judgment procedure?
I think there may be a lot of traps in the summary judgment procedure in Florida, simply because the Florida Supreme Court adopted the federal summary judgment standard just a couple of years ago. And so all the requirements under that rule are being fleshed out in Florida still. We do have Rule 1.510D, again, that's modeled after the federal rule, and it says, if a non-movement shows by affidavit or declaration that for specified reasons it cannot present facts essential to justify its opposition, the court may defer considering the motion or deny it, allow time to obtain affidavits or declarations to take discovery, or issue any other appropriate order. And so there's a question as to whether this is the only way to get a continuance of a summary judgment decision. What constitutes an affidavit or a declaration? Do you need to file a separate motion, or can you make the showing required under the rule in your response? So I think these are things that we're figuring out in Florida right now.
Yeah, that's a good question, and I think when you read that Florida rule, it does sound, from what I recall, almost identical, that affidavit or declaration. And it was not clear to me last time I read Rule 54 whether you could just file a declaration the day before the hearing or the day of the hearing, for that matter, and say, look, I complied with the rule. I need more discovery. You have to continue or deny the motion, or does it have to be in a notice motion or an ex parte application? That's a good open question. I don't know if that's been resolved under Federal Rule Civil Procedure 54 either. But I guess
I'm not reading the rule as saying it requires a separate motion. I know that in the 11th Circuit, you don't even necessarily have to provide an affidavit or something under penalty of perjury if you're an attorney making the representation to the court. The 11th Circuit says an attorney is an officer of the court. If you're telling the court reasons that you need more time, then that ought to be good enough.
Yeah. So. Let's talk about oral argument in our respective appellate courts. In California, litigants have a right to oral argument. Some Court of Appeal jurists wish that litigants would waive that right more often, but there are different schools of thought of whether you should waive it. I think I've come to the side that says you probably should never waive it, after talking to one retired Court of Appeal justice who said, I always got a little bit of a weird feeling whenever a party waived a right to oral argument. I wondered if it meant they didn't feel that strongly about their argument. So if there's a chance that's ever going to be the thought running through the mind of one of my panelists, I'm sure not going to waive oral argument again. What about in Florida, Lindsey? Is there a right to oral argument in the Court of Appeal?
No, there's no right. In the district courts of appeal, you generally have to request it if you're going to get it. The appellate court can order oral argument on its own motion, but very rarely does that happen in the district courts of appeal. It happens regularly in the Florida Supreme Court, but in the DCAs, you need to ask for it, and you need to ask for it not within your brief, but you need to file a separate request for oral argument as its own distinct document. And I believe that's due after the reply brief. It is. And yeah, but you don't have a right. I've heard the same type of thought that you expressed hearing from a judge, that there are some judges out there who have said, if you don't request oral argument, it's not a waiver issue, but if you don't request oral argument, then they question whether you have a good case. I've heard a lot of judges say the opposite, that it makes no difference. I err on the side of asking for oral argument.
Yeah. What about in? I wonder if this is a universal feeling as well. That do oral arguments change the outcome? Have you ever come out of an oral argument thinking, "Gosh, based on the questions and the responses to my brilliant answers from the panel, that I think they're really going my way now. They started kind of hostile to me, but by the end I had the meeting out of my hand." You ever get that idea that that oral argument really turned the tide of your case?
I wouldn't say no. I don't think so, because I usually think my briefs are strong enough that going into it, well, they probably were convinced by my briefs, right? At oral argument, I sometimes look back and say, "Oh, I should have answered that question a little better." If only I had said this, use some magic words differently, then maybe they would see the case differently. But in reality, my experience tells me that I don't think oral argument makes a big difference typically.
I think that's that may be close to a universal feeling. I think it's it's sometimes more for the benefit of the client than for the Court of Appeal, and it may be good for the attorney's ego as well. It might not be too dissimilar from the ceremony of reading jury instructions. It's something that that is important to the process, but does it really make a difference to anything? Well, let's talk about you on a similar note to what you just said, Lindsey, about oral argument. And sometimes you wonder, coming out of an oral argument, gosh, maybe I could have answered this question a little bit differently. Sometimes Court of Appeals in California will issue focus letters, letters to the counsel that say, at oral argument, the panel is interested in hearing more discussion on this specific issue. Be prepared to discuss that. Or they will publish or deliver a tentative opinion, so you can see exactly where the Court of Appeal is going in its reasoning. Does that happen in Florida? And what's your reaction and the reaction of the bar to those types of maneuvers?
Focus orders do happen, not that often, but I think we're seeing them. I think they're kind of a relatively new thing, and so naturally we're starting to see them more. I think it's a great idea for the courts to issue focus orders. It just, for obvious reasons, it helps the appellants and the appellees get prepared to know what the court actually wants to hear about, which I think would make for a more productive discussion. Now, I have not seen a court in Florida issue a tentative opinion. That would be neat. I like the idea, but I don't think it's likely to happen. Does that happen very often in your jurisdiction?
Not often. Jeff, do you remember which districts do it?
So yeah, there's one division in the 2nd district, and then there's one division down in the 4th district that does tentatives, where you get actually in the 4th appellate district, division 2, you can actually get the full opinion, fully baked. Yeah, but it's the minority position. Most of the courts let you just come in and guess what's on the justice's mind.
Yeah,
I would think the court. I was thinking, I would think by the time a panel wrote an opinion, they would probably be ready to dispense with oral argument. I don't know.
Yeah. I'm told there's two main reasons why courts don't do more tentative opinions. One is justices that the authoring justice may if something does prove incorrect as at oral argument, if one of the main points are refuted at oral argument, explain why the justice was incorrect, then that could result in a bruised ego, and so there is maybe a reservation against doing that and exposing at that point inchoate analysis to the attorneys to be picked apart is maybe not something that the justices are accustomed to and that enjoy doing. And then the other reason would be the reason most often given, because this is like you said in Florida, Lindsey, still something of a recent development in the appellate courts. And so anytime there is an appellate conference featuring an appellate justice, you can bet that one of the questions they're going to be asked is, why aren't you doing more focus letters and and tentative opinions? And the reason that's most often given, that I think is the best one, is that look, when we give these focus letters or the tentative opinions, the attorneys come in and they're certainly very well prepped on those issues, and they're but almost to a detriment, because they're so laser focused on those issues that we kind of miss when they would normally come in not knowing what we're thinking, what issues we're honed in on. They would come with a broader, more holistic view of the case, kind of give us a roadmap, set the tone, introduce the parties a little bit, kind of taking another run at teeing up the case for us and giving us a new lens through which to see the case. But when we give them a focus letter, they're coming and you're ramming this issue right down our throat. And not to say they're not great arguments, but we're missing the bigger picture that we would have gotten if we hadn't issued that tentative opinion or focus letter.
Mm-hmm. Yeah, that makes sense.
Any other common traps that you see in Florida civil procedure, appellate procedure, or the rules of procedure in Florida that you think are pretty good and that other jurisdictions ought to consider adopting them? And you had mentioned earlier about something about the requirement of requesting findings of fact.
Yes. Yeah, the reason you tripped me up is because you said are pretty good, and I think other jurisdictions should follow them. I'm not so sure about that, but there has been a recent amendment to the Florida Rules of Civil Procedure. I'm going to pull up the language here. So there's a new rule. It's an amendment to Rule 1.530 that says, to preserve for appeal a challenge to the sufficiency of a trial court's findings in the final judgment, you must raise that issue in a motion for rehearing. Before this rule amendment, I think 3 or 4 of the district courts already had that rule. They would often find things not preserved for failing to, they would often find issues about insufficient findings of fact unpreserved because it wasn't raised in a motion for rehearing. Now that's the rule across all the districts in Florida by virtue of this rule change. So I don't know if it's a great rule or not. Obviously the Florida Supreme Court thought it was, but and several of the districts thought so ahead of time. But it certainly could be a trap if anyone's unaware of that rule change. And the way that it comes up a lot of times is for example, in family law cases, there are judicial opinions that say a court must make express findings on various factors that the court had to consider for child custody issues or equitable distribution, things like that. And so if your only issue that you're arguing on appeal is that the trial court did not make sufficient findings on those factors, then you're not going to be able to raise that unless you preserved it with a motion for rehearing.
That sounds similar to some of our procedures in California about statements of decision, they're called, after a bench trial. You don't get a verdict, obviously. So if you want to know what the fact finder thought about issues, you have to request that the judge issue a statement of decision. And if the judge doesn't issue findings on the issues that were important to you, you have to specifically request findings on those issues and object that they were not made. And if you don't do any of that, there's like a 2 or 3 step process. If you miss any part of that process, you're deemed to have waived a right to a finding on that issue. And then you're up against the doctrine of implied findings, that any old thing that could be used to affirm that judgment will be inferred against you. And then substantial evidence, and as long as it's backed by substantial evidence, which is almost synonymous with any evidence, then it's going to be affirmed.
Oh, that's interesting. So in Florida, we have a similar rule, but there is kind of an asterisk that I would add to it. So it's in Florida, there's the rule that if the trial court reached the right result for any reason, then the appellate court will affirm. We have a little nickname for it called the tipsy coachman doctrine. which comes from a poem. You've heard of this?
I remember reading about it on your LinkedIn, I think.
Oh, really? Okay. So it comes from a poem about a coachman, which is, the driver of a horse-drawn carriage, who is apparently drunk, but gets to where he's going anyway. So for whatever reason, the appellate courts have nicknamed this doctrine after that poem. But the caveat that I'm not sure is the rule in Florida based on in California, based on what you just said, is if the application of this doctrine would require the appellate court to make a finding of fact that the trial court did not make, then the appellate court won't apply it.
I like the name tipsy coachman doctrine better than the boring old implied findings doctrine.
Yeah, a little more catchy.
I'm going to start using it.
All right.
I will say, the implied findings, maybe that's a little different of a thing. Because I know, for example, if the appellate court is reviewing, a decision on a motion to suppress, and the court didn't make express findings, the court's going to assume that the court made findings in support of, made the requisite findings, even though it didn't say them expressly.
All right. Well, now Jeff has to ask you a set of the hardest questions of them all. So I'm going to hand you over.
Okay. And, first, I guess a trigger warning for our audience. If the word that offends or triggers you in a sentence, I'm about to use the word twice. So here we go. This is the time for our patented copyright segment of the show that answers the most pressing questions that vex appellate nerds around the world. The dreaded lightning round. We're looking for short responses of one sentence or less. Let's see how far we can go here. Font preference, Century Schoolbook, Garamond, or something else?
Something else.
What?
You want me to say something else?
Don't say Times New Roman. Don't say Times New Roman.
I kind of want to say that. I actually like that better. But I would, in our courts, I know I'm supposed to be going fast. In our appellate courts, we have to use Arial or Bookman Old Style now. So I would be partial to those.
Okay. Well, that's a new entry.
If I can't have time.
Okay. After period, 2 spaces or 1?
Definitely 1.
All right. Fantastic. Pled or pleaded?
Pled.
Fantastic. And when you're doing the major argument headings for your briefs, all caps, initial caps, or sentence case?
Initial caps.
All right. And as a bonus sub question, when you're doing initial caps, do you capitalize every word or just those that are 4 letters or more? Or which words do you capitalize?
Just those that are 4 letters or more. I don't know that I've ever thought about it as 4 letters or more, but I do think of it as kind of the rule taught back in maybe elementary school about when you capitalize words in the title of a book. So you wouldn't capitalize a or the or similar words.
But what about verbs? Like is only a 2-letter word, but it's a verb.
Don't capitalize.
Good question. I would probably struggle with that one on a case-by-case basis.
Yeah, you'd have to phone a friend for that one. Okay, I think you did fairly well. You stumbled a bit on the font question. We'll give you 9 out of 10 on that one. Congratulations on surviving the lightning round. We'll send you a mug as a thank you for appearing on the podcast and surviving the table or the round.
I have to now that I got into fisticuffs almost with John Nielsen about possessives of words ending in s. So the example I used was how do you make a possessive of the word Congress? Is it Congress apostrophe or Congress apostrophe s?
I would put that apostrophe s on there.
Yes, thank you. I'm going to tell John.
All right.
Yeah,
you could cite Lindsey.
That.
Don't cite to Lindsey, but you could cite Lindsey for that proposition.
There you go.
That's right. That's the takeaway.
Yeah.
All right.
All right. I think that's gonna wrap up this episode. Again, we want to thank Casetext for sponsoring the podcast. Each week we include links to cases we discuss. We use Casetext for that. Listeners of the podcast can find a 25% discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
Yeah, and if you have suggestions for future episodes or if the word that offends you, please email us at info@calpodcast.com. And in our upcoming episodes, look for tips on how to lay the groundwork for an appeal when preparing for trial.
Thanks again to Lindsey Lawton for joining us.
Thank you for having me. It was fun.
All right, see you next time.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.